All right, well, we got that part figured out. So, hi everyone. A lot of us, you probably know us from the real estate side of things, NIP Law, but we also do estate planning and we do estate administration. And that is what we are going to be mainly talking about today and how that can affect your business. So like I said, residential real estate, estate planning, probate. We have offices in North and South Carolina, although we only practice estate planning and administration in North Carolina. We're also members of the American Academy of Estate Planning Attorneys. It's a national organization of estate planning attorneys. It's a really great network for us for resources, and they have a great education department. So when weird things come up that we haven't seen before, we have a great resource to reach out to for any questions. Now, specifically about us, you thought you were just getting me, but you're getting a 2-for deal today because Tara is joining me as well. So I'm Beth Marks. I'm our managing estate planning attorney. Way back in the day with NIP Law, I actually did work in real estate. So I do have some real estate knowledge as well. I did not love real estate, no offense to all of you lovely folks, but I ended up doing estate planning, and I really found something that I really enjoy and really think is important and helpful to people. And it's really my thing. Tara has been with NIP Law for 1 whole week and a day. She is not a new attorney, but she is a new attorney to us, and she has come along to help with estate planning and estate administration. And she really is going to be the main contact for estate administration. All right, so here's what we're going to talk about today. I don't know how to make that so it's not over part of the slide, but you can probably figure out what it says after that. So what is estate planning and why does it affect you? Oh no, oh no. Selling the home of a person who's passed away, and then we'll give you a simple solution to the problems that can arise with all of those things. All right, so part 1, what is estate planning and why does it affect you? I'm going to hand it over to Tara for this portion.
All right, so most of you probably, when you think of an estate plan, you think of a will or a trust, but there are other documents that are involved, such as a durable power of attorney, healthcare power of attorney, living wills. Sometimes you're going to have deeds that are involved. And then, of course, you're going to have to think about probate, what happens when you pass away. So an estate plan can encompass what you're going to do when you are incapacitated. So let's say you get in a car accident and decisions need to be made, whether it's for your health. Your healthcare power of attorney can handle those decisions based on things that you have already decided if you have that document in place. Then your durable power of attorney can help with, let's say you've got your power bill or something that needs to be paid. If you're incapacitated, obviously you're not going to be able to do that. So those people can make those decisions for you as if they were you. Again, it is really planning for what's going to happen when you pass away. You have assets such as your bank accounts, your brokerage accounts, your house, real estate investments, all of those types of things. Your estate plan is really to figure out what's going to happen to those things. A lot of times, if you don't have something in place, there can be disagreements among your heirs. The beneficiaries may feel like they've got a claim to something that maybe you didn't actually want them to have a claim to. Sometimes you're going to be a really wealthy person and really be successful in your real estate careers, and you'll have made over $12 million if you're an individual, or $24 million if you're married. And then you would need to do some tax planning if you're at that level. You need to kind of think about those types of things as you are thinking about how you want things to pass. Again, so you're going to be thinking about your real estate, your bank accounts, your investments, your vehicles, any personal property. All of those types of things can be handled in your estate plan. And if you don't have a good estate plan, so a lot of times when we're talking with our clients, they'll bring in something that they did on the computer, on the internet, or I don't know, Sally down the street helped them draft. And they'll have wound up giving things to people that don't exist, or the wording is just so convoluted that you can't tell who's getting what. Sometimes you create a trust that costs thousands of dollars and then you don't fund it. So it's just paper. So you really need to think about, okay, if I'm creating this trust, what do I need to put in the trust? How do I need to put it in the trust and get it done? Because otherwise it's nothing. All right, so when you're dealing with your clients in the real estate world, if one of them was to pass away, you have to kind of think about, okay, who is actually the owner of the home now? Who are you working with, and who is your actual client? So if somebody passes away, well, let me get to the next slide. Okay. If you're working with somebody who is trying to sell a home of somebody that's deceased, do you know for sure that they have the legal authority to do all the repairs that are needed to the home? Who's paying for these repairs? Who's going to be keeping the house up while the house is for sale and maybe going through the probate process? So those are things that you need to think about before you're actually getting the house put on the market. Along with that, you also need to think about the families that are involved. So maybe one person is handling the estate, but there's another person who's super loud and super in your face and trying to get things done. You need to think about who actually is the person who's going to be the decision maker in that process. And just as like if you were dealing with somebody who was alive, you still need to think about all of these types of issues when you're going to put it on the market. If there is somebody who has passed away or passes away in process, you know that there's going to be an estate process if they pass away and you're under contract, right? So these are all the things that you kind of need to think about along the way. Okay. And same thing here, you need to really consider who you are actually working with.
So once we figured that out, then what is the process? What does that look like? So again, when a lot of people think about, or most people think about estate planning, they think of a last will and testament. That's really only one of the many estate plans that someone could have. The most common estate plan, sadly, is dying without a plan. And in that case, North Carolina law becomes your estate plan. And a lot of surveys indicate that there's over half of Americans that don't have wills. And I won't ask you to raise your hand if you don't have a will, but I would bet we are probably close to that percentage just in this room. So what happens? North Carolina law decides where the assets go. It is not often distributed the way that you might think it would be. It doesn't necessarily follow what people think, how it should work, or common sense. So I have a couple of examples here. So husband was a sole owner of a house prior to marriage. After marriage, no change was made to the deed. The husband dies with no will. That's what intestate means. And his wife is left, and he also has living parents, but they had no children. Anyone have any ideas on who owns the home now? Partially, yeah. Yep, so under intestacy statutes, his heirs are his wife and his parents. So his parents own a quarter, wife owns 3/4, I guess if we're doing percentages. That's a surprising thing that when I talk to clients, especially married couples without kids, I like to ask them, how do you feel about your in-laws? And oftentimes, even if people like their in-laws, they don't want to be owning property with their in-laws. And a lot of people just assume like, well, I'm married, if I die, my spouse gets everything. And that's not how it works. So keep that in mind. Okay, this is a real life situation that we had at NIP Law. So wife owned the home prior to marriage, got married, didn't make any updates to the deed. The wife, in this case, actually did die in a car accident right after they had had a child. She did not have a will. So rather than asking the question, I'll tell you what happened. 12 years down the road, husband decided to sell the house. He assumed that he owned the house because his wife had owned the house and now she had passed away, and now he thought he owned the house. Anyone have an idea of how that went? he owned part of the house. He did not own all of the house. He owned the house with his now 12-year-old daughter. Anyone think a 12-year-old can be signing a deed at closing? No. So there was no estate that was ever opened. What was going to happen is they were going to have to basically apply to the court. The court was going to have to approve the sale on behalf of the minor. And even if they did approve the sale, her half of the proceeds weren't going to him to buy a new house. They were going to be held in, some kind of an account probably managed by a clerk or a trustee or something like that. So this really did happen several years ago at NIPLAW. We never did the closing. I don't know what happened. The sale contract we had fell through. And I don't know if they ever were able to get the home sold, but if they were, it wasn't quickly. I can definitely guarantee that. All right, so different types of estate plans you might encounter. Joint tenants with rights of survivorship on a deed can be considered kind of part of an estate plan. So that's when there's multiple owners on a home and basically the last man standing owns the house. So if, two people own that way, one dies, the other absorbs the interest and owns the house outright. It makes it a non-probate asset, which means it doesn't pass through the will at that point. If there's still someone alive on the deed, they get the house, doesn't pass through the person who passed away's wills. However, the line on the bottom, multiple owners on a deed does not automatically mean joint tenants with rights of survivorship. So that is something to keep in mind. So ways to hold joint title in North Carolina. The first one, tenants in common. And that's what's presumed unless something else is stated on the deed. So if there's two people named on the deed, that's how they own the property if it doesn't say anything beyond that. Each person owns their share of the property. So if it was two people, they each own half. And the person who dies, their share passes through whatever their estate plan is, and the other person retains their half. Middle option, joint tenants with rights of survivorship, has to be specified on the deed. It has to be these two people, joint tenants with rights of survivorship, or some very close variation of that. And again, this is when, if one person dies, last man standing owns the home, and no probate required until there's only one person left and that person dies, then we may be looking at probate. And then tenancy by the entirety. So that is a specific to North Carolina. There are some other states that have it as well, but not all states. It's only available for married couples. And it's presumed as long as they're, it's indicated on the deed that they're married. So if it says, Joe and spouse Sally, tenancy by the entirety is presumed. Same as joint tenants with rights of survivorship, in that last man standing owns the home, but it also provides a layer of creditor protection. Not sure if you guys have run into this, but basically married couple, if one person has a lien against them, a judgment against them, and it's only against one spouse, and they own this way, joint with tenancy by the entirety, the lien doesn't attach to the house, which means that it does not have to be paid when the home is sold, as long as it's only against one spouse. So that is a great argument for someone who bought a house before they got married, and then now they're married, they should update their deed, because it does give protection. And I see it, or I did when I worked in the real estate portion all the time on title searches. There's a lien against one spouse, does not attach due to TBE, tenancy by the entirety. Okay, so case study number 2. What type of ownership is this? So scenario 1, Beth Marks and Tara Brown. How do we own the property?
Anybody want to guess? If it just says Beth Marks and Tara Brown.
Tenants in common, that's right. We each own our half. Second one, Beth Marks and Tara Brown, joint tenants with rights of survivorship. Very obvious that is the survivorship. And that is bingo if you are trying to sell this house for the last of us that is living. That means you do not have to worry about any kind of a probate scenario. All right, number 3, Beth Marks and spouse Michael Marks. Yeah, tenancy by the entirety. It doesn't have to specifically say that. It says he's my spouse, so that means that's how we own the property. So if I die in scenario 1, who owns the property? Yep, my heirs and Tara. So depending on if I have a will or don't have a will, what my will says, that's who owns the property. In scenario 2, if I die, Tara owns the property. And in scenario 3, if I die, my husband owns the property. Okay, so different types of estate plans you may encounter. So we already talked about the most common, which is no estate plan. Probably the next most common is going to be a last will and testament. So that's just a written set of instructions saying whatever I have when I die, here's where I want it to go. And also names who's going to be in charge of that process. A will typically means probate, depending on what the assets are. Some people think, and I get this probably every week, someone I talk to says, well, if I have a will, I won't have to go through probate. Not true. And the easy example that I use is if Tara leaves me her car and her will and she dies, I don't just go to the DMV with the will and pick up the title. There's more to it than that. There has to be some legal authority behind it. Now, in real estate, it gets a little bit confusing because the real estate statute that talks about this can be confusing. And what it says is basically at someone's death, the home vests in the heirs, which means they own it immediately. So why would there need to be probate? Well, title insurance is why there would need to be probate. The will usually, it means probate if they want to, if the heirs, whoever's inheriting the house, oh yeah, sorry, that's the actual statute. If the heirs inheriting the house are gonna wanna sell the house within 2 years, they're not gonna be able to get title insurance unless probate is open with the county. So technically the heirs own the house, but they can't, the buyers aren't going to be able to get title insurance, which is required, by the contract. This is the actual wording of the statute. And as you can see, all statutes are written to be so understandable. So, but it does say it immediately will become vested in the devisees as of the date of the person's death. But keep that in mind. So if you have someone who's passed away, the heirs are wanting to sell the house and they said, oh, grandma died in 2010. You're probably in good shape, even if it wasn't a probate opened. If someone's trying to sell a house more quickly than that, and to be honest, that's the more typical scenario, they're probably looking at some kind of a probate process.
How long does that take?
We tell clients 9 to 18 months. So now we'll talk about it a little bit more later. That doesn't mean 18 months before they can sell the house. But the start to finish process of probate can take that long, or longer if you throw in a global pandemic, we found. Next most common type of estate plan would be a trust. Typically you'd be dealing most commonly with a revocable living trust. Says like a will, but on steroids. A trust, what I tell people is think of a trust like a box that you can put your belongings in during your lifetime. So your home is in the trust, your bank accounts are titled in the name of the trust, your business interests, your car, your investment accounts, all of that can be titled into the name of the trust. Even though you are in full control of the trust during your lifetime, you don't technically own the assets when you die, your trust does. And because of that, nothing in the trust is subject to probate. So generally much easier to navigate. So if you see a trust as an owner on a home you're trying to sell, you will probably feel better than if you see someone that passed away 6 months ago, especially if they had no estate plan. Then we said an attorney's favorite, do-it-yourself estate plans. We have a lot of people who try to do wills on LegalZoom or different, online scenarios. I can't say that all of those wills are terrible, but I can tell you that I have not seen a good one yet. And the problem with them is a lot of times you don't see them until it's too late because the person who created it is gone. One of the more recent ones I had, there's signing requirements for wills in North Carolina. They had witnesses, which was great. Witnesses signed the will, but it wasn't notarized. So it was not what's called self-proved, which meant that if we could not track down the witnesses, we were going to have to do a lot more work with the court. Luckily, they were the neighbors of the person who passed away and still lived there. So we just had them sign an affidavit and we didn't have to, hire a private investigator to try to find these people. But yeah, they're rarely good. And the problem is you don't know what you don't know. So you put something together and you think, wow, I did a will. What a great thing I've done for my family. And it could be a total disaster when you pass away. Family disagreement. So like it says here, the sale, like a parent's home, sometimes is the final battleground for siblings that didn't get along. It doesn't usually have anything to do with the house itself, but kind of prepare yourself when you're dealing with anything coming out of an estate, and try not to get bogged down in the family disagreements. Know who the decision maker is, deal with them, and let them figure everything else out. Okay, so as far as figuring out who has legal authority, just because a will says someone is the executor does not mean that they have the authority. They are not actually the executor until the court appoints them. So just a will saying that daughter is executor is not enough. The will has to be submitted to the court. The court has to approve and say, yes, this is a valid will. And then they officially appoint the executor and give them what's called letters. Letters testamentary if they have a will. That is what the title insurance company is going to want to see to verify that this person has the authority. So that they do have to be formally appointed. So just because there's a will doesn't mean that you're in good shape unless, you know, they've kind of already started the process.
So does the executor then have to go to the courthouse and?
They have to sign documents. Yeah. I mean, they start signing like an oath and, you know, saying that they're going to do the job, and, you know, they sign off on everything. They don't necessarily have to go to the courthouse, but someone has to get documents to the courthouse.
It's basically an application to the court to ask if it's okay that I am the one that is in charge.
What's that? The application isn't. I mean, it's basically, you know, saying who passed away and when and who we're trying to appoint. You would give them the original will that says this is the person who died wants to appoint. And then, like Tara said, an application, an oath. They can even be out of state. I've done a probate where I never met the executor in person. We talked on the phone. She lived in Texas. And it was an Iredell County one. So we FedEx documents back and forth because she had to sign documents that were notarized. But she was never physically in North Carolina during the process.
So that doesn't apply to a trust then?
Nope, nope. All right, so if a person died without a will, someone still needs to be appointed. What do they call it? A personal representative at that point. It's not technically an executor, but it's basically the same job. And a lot of times it's some family member that volunteers and says, okay, I guess I'll do this.
It would still be letters, but it'd be letters of administration.
Yeah, they still have to have authority from the court saying that they've been appointed to do this job. So remember that the family member doing all the work might not be the one with legal authority. The family member that yells the loudest might not be the one with legal authority. So like we said earlier, determine who has that authority first. Okay, so now it's time to sell the house. How is that going to work? And this might be a scenario, hopefully, that you haven't dealt with, but we've seen it over at NIPLAW a couple of times. We get close to the closing and all of a sudden, there was no estate opened and the title insurance company is requiring it. Now what? Okay, so let's start with the easiest plan to deal with, and that would be the revocable living trust. Basically what you need to supply to the title insurance company is the certificate of trust, which is their authority document. It says who has the authority to transact on behalf of the trust. We give a certificate of trust with all the trust packages we do. I just did one for someone, a married couple, the wife passed away, and now the husband's the sole trustee. So I did an updated trust certificate for him so he can manage the trust. Ownership by a trust, unless it's not a good trust, which is also possible, but it likely will make the closing go smoothly on your end, particularly. Again, if you have joint tenancy or tenancy by the entirety, there's no probate. I've had realtors call and say, oh, you know, this person, they want to sell their house, their husband died, what do we do? I said, well, were they both on the deed? Yes. Were they on the deed as a married couple? Yes. Perfect. Sell the house. So like you only need the spouse that's still living to do it. But just remember that multiple owners doesn't mean it's with rights of survivorship. So make sure you actually read the deed and see how it's titled. So anything else, you're likely going to have to deal with some form of probate unless, like I said, that 2 years has passed. If the person had a will or they died without an estate plan, kind of, you know, think about that and try to spot it early on, because the earlier you tell the closing attorney what's going on, the earlier you're going to know if your client needs to contact an attorney to open an estate. And none of it's fast. Some counties are faster than others, but you know, if this isn't figured out until a month before the closing, it's going to be pretty tight being able to sell the house on time.
Mm-hmm. What if there is a will, the person that owns the house dies, so now the executor has to sell this property. That property has a reverse mortgage, which means it needs to be sold sooner rather than later. But you gotta wait that probate period, right? Because the new buyer won't get title insurance.
Yeah, so it's not. I think it's later on in here. But once the probate is open, most title insurance companies will insure the property once you get to a certain point, and it's close to the beginning. So the first thing that happens, like Tara said, is an application is submitted with the will and all of that. Once that's like approved and the estate's officially opened, you have to run a notice to creditors. That has to be published and it runs for 4 consecutive weeks weekly. Most title insurance company, once that notice has run twice, they will insure the property. So it's close to the beginning. Now, your clients might not have access to the funds from the closing until, you know, everyone's sure that there aren't creditors. But as far as the closing actually happening, you're not waiting the full like 18 months for that typically. Agree? All right, this is just a fun little quote here. Keep this in mind. Probate, like I said, it's never a short process, or rarely, at least not in this state. I think the quickest one I ever did was 4 months. It was only a house. It was this person I told you about that lived in Texas, the executor. House, nothing else, no debt, before COVID in Iredell County, which is an easy county to deal with. So 4 months was my world record. Okay, so again, you know, the closing attorney, the title insurance company, they will work out and tell you what needs to happen if you don't know. So don't feel like you have to be an expert on probate to do this, but at least be able to spot issues before, you know, it gets to be too close to the closing to make everything happen on time. So we've already talked a little bit about this. It's the legal process of retitling assets when someone dies. Gives the family the legal authority to sell or transfer assets. And a lot of times they're doing that with like vehicles and things during the process too. They don't have to wait until the end to sell everything. The only thing that can happen is the funds can be tied up, because really one of the big purposes of probate is to make sure creditors get paid. So anyone who is owed money has to get paid. So that means the money can't go out of the estate until the court is satisfied that that's happened. So we already talked a little bit about this. We tell people 9 to 18 months. Do you think that's a good average? You know, it depends a lot on a lot of things. It depends on what county you're talking about. Some counties are easier than others. We are right now standing in a county that is an easy county to deal with. Mecklenburg County is not. They are not fast. They're probably the worst one locally that we deal with. Depends on how much debt is there, what kind of assets were there, how organized was the person that died, how easy is it for the person who's handling it to figure out what they're even looking for, what time of year does someone die. We had someone who passed away in February of last year. We have waited a full calendar year to file his tax return for that year, because that's something that has to be finalized before the estate can be finalized. So depends on a lot of different things. If your client, or if a person owns real estate in multiple states, they might have multiple probates. They would have their main probate if they lived in North Carolina here. If they had a vacation house in South Carolina, Florida, wherever, they're going to have a secondary ancillary probate there. So instead of dealing with one state's laws, you're dealing with 2. Also, all the records are public. Clients are usually surprised. I actually had we had a client call us, and she was furious that her phone number was listed on the court documents. She was the executor. All of that was required. We had to put her information on the document, but everything's public. So if you want to go pull a probate file, you can see what this person owned when they died. There's a full inventory that's included and who got it. So that is all public record. I don't know if people are doing that, but they could. Yeah. Yep. Still me here. On a roll. All right, so who signs the deed? Okay, so title held, Beth Marks and Tara Brown, trustees of the NIP Law Trust. Tara dies. Sorry, Tara. Who signs the deed? Me. That's it. No probate, nothing. If I'm the trustee of the trust, I can sign the deed to sell the property. All right. This one, kind of a repeat of some of the other questions. Who signs the deed in this case to sell the house? Yep, Michael. It says and spouse under there. Sorry, it's hidden by my face. All right, Beth Marks and Tara Brown, joint tenants with rights of survivorship. Oh, you know what? Back on the last slide. Who signs the deed if I have died and my husband survives me? My husband, unless he remarried. If he remarried, then guess what? His new wife signs the deed too. Okay, Beth Marks, Tara Brown, joint tenants with rights of survivorship. Tara dies this time. Who signs the deed? Oh, rights of survivorship. That's the golden ticket. Yep, so just me and my spouse, if I'm married. I'm sure you guys have all encountered marital interests and know that spouses always sign. Okay, Beth Marks and Tara Brown. Tara dies with a will. So who signs the deed to sell the house? So we have me, I'm still alive and I own half. So I sign the deed, my husband signs the deed. Tara had a will, so whoever Tara's heirs are sign the deed. If probate is still happening, if it has not been closed, then all of the heirs' spouses sign the deed as well. And even if it has been closed out and is done, spouses sign as well. We also had a closing, I think that was earlier this year. Yeah, earlier this year, it was a property that people had died and died and died and died and never was a probate opened. And I think there may have been some wills interspersed in there, some with wills, some without wills. I think it ended up that there were between 30 and 40 people that had to sign the deed to sell the house. And they appointed 2 of them as powers of attorney. So 2 people with power of attorney had to sign the deed, 30 to 40 different signatures. It took, I think, an hour just to get through all of the signing on the seller side. So that is something that, our title attorneys dread because it's a lot of going to courthouses, pulling old files, pulling probate files, finding wills. If there wasn't a will, they have to figure out who this person's heirs were. So they're looking at heirship affidavits. That one was like a victory dance when that closed. But yeah, that was a tough one. Okay, so I own the property by myself and I die unmarried without a will. So whoever North Carolina determines my heirs are, and I think it's my parents at that point, right? I don't have kids or a husband.
Whoever is living, your heirs, yeah.
Yeah, I have two living parents right now, thankfully, so they would sign the deed to sell my house. All right, Nasadowski, that's my maiden name. Beth Nasadowski, Michael Marks, unmarried and unmarried. I die without a will, and I have a minor child. So who signs the deed? So who's out of luck? Michael Marks, he still owns his half, but he did not get my half. My child gets my half, I think full that time, right? No parents involved that time. So if I have a minor child, no will, and Michael Marks wants to sell this house, he is going to be in the same situation that I told you about earlier that we had the seller in.
What if you have a couple with a child? No will. Both parents died tragically in a car accident. And this child that's
You get
under
this
age.
one.
Who does this go to?
It's gonna go to their child, but it'll go in trust. So the court will have to establish a trust for the child.
And it's only until they're 18.
Yeah.
So you don't get to pick what age they get it at. And I think one of the clerks basically acts as the trustee at that point. So someone at the courthouse that nobody knows is now the trustee.
So if that child then turns 18, so if the child's 18 when the parents died,
Right.
Or in equal shares to all the kids if there were multiple kids. But yeah, if they're over 18, they get it outright. If they're under 18, it's held and managed by clerk Tommy at the courthouse. All right, a lot of fees to be considered in probate: court fees, attorney fees. The personal representative or executor can be paid for what they're doing. It's a job, so they can take money and be paid for their services. Just as an example, for probate for us, we take a $2,500 retainer and we bill out of that hourly, $250 an hour for attorney time, $100 an hour for paralegal time. I think we're on the cheap side. Court fees can vary. It depends somewhat on what the value of the estate is. So they can be, higher or lower depending on what assets we're talking about.
So if you have a trust.
No
then there's none
probate.
of that.
Correct.
Unless your trust sets aside money for whoever the trustee is to handle it.
Yeah, trustees can be paid for their services. A successor trustee can be paid, but no court fees or anything like that. Your trust shouldn't be going to court unless something's gone wildly wrong. Okay, so what do you do if you have a client that needs to go through probate? Call an attorney. That's what you need to do. You don't have to try to sleuth it out yourself. All you have to do is figure out that there is a potential issue here, and we need to call the attorney. So again, the standard contract requires that the seller convey marketable insurable title. So that's where the hang up often is. Title insurance will have requirements. Depending on the situation, like I said, the heirs may or may not have access to their proceeds. But at that point, your job at least is done. The house can be sold during probate, but sometimes the funds are hung up for the seller. Okay, so just some kind of general recap questions. Was there a will? Has an estate been opened? Has a personal representative or executor been appointed? Has the notice to creditors run? Has the final accounting been approved by the clerk? How long ago did the person die? That's all stuff that is necessary to know. If the final accounting's been approved, then probate's over. You missed all the fun and came in at the right part because probate's done if the final accounting's approved.
All right, so the homeowner passed away. I don't know.
I think it says last month.
Okay, last month. Homeowner had a will that names only the daughter as executor and sole heir. Daughter has contacted you to list the home. What do you do?
Oh no, that's a different one. Sorry, I messed up.
Well, so what would you do if you had the daughter contact you? Okay. And yeah, that's probably
we did it.
Yeah, if she has open probate, then you want to get a copy of the letters to see if she actually has the authority. Okay, daughter recently lost her job and wants to sell the home ASAP. What questions should you ask? What are the potential problems you may encounter? That kind of goes hand in hand with what you were just saying. Just make sure that the estate has actually been opened because like we've said, if it's before 2 years, you're going to have that estate opened and the creditors have to have the opportunity to claw it back in.
Yeah, I think that's the statute of limitations is 2 years on an estate.
Yeah. That's why, because you can't have marketable title if, yeah. Okay. Oh, this is.
Yeah, so this is just a quick slide. I don't know if you guys deal with Tamara from our office at all, but she told us to include this because this has actually happened recently at NIPLAW. Death of a buyer or seller under contract. In the case of the buyer under contract, I think that's the one we had recently. It was a married couple. So her advice was, don't freak out because the survivor might still have the ability to qualify and just kind of give them some time to breathe. Don't, say we have to close right away. I think that's kind of what happened in our scenario is they were pushing this widow or widower to close like immediately on this house when they're dealing with the death of their spouse. If a seller is under contract and passes away, the personal representative, the executor, can sell the house. They have to open an estate to make sure that they're officially appointed, but in that case, they don't have to wait for the creditor period to run because it was the seller's intention to sell the house. All right.
And then that money that they made goes in probate, or they have a will.
I don't know what happens with the funds in that case. Do you know that answer?
It would because they would
Probably still have to wait to make
Mhm.
sure they didn't owe anyone money. I
Yeah.
think that's the whole crux of probate almost. Okay, so we need a solution to some of these problems, and this is more geared toward you or even encouraging your clients to, get their affairs in order. So the trust, again, I already gave my box analogy. Think of it like a box. One analogy that I also use now, there's no liability protection necessarily, but think of it like an LLC. If you and your spouse form an LLC, you're the only members, you buy a building, a truck, and have a bank account, you still have full control over it, even though it's titled in the name of the LLC. Same kind of idea with the trust. The trust technically owns the property, but you're running the show. It provides key instructions on who manages assets if the owner becomes incapacitated and what happens to assets when the owner dies. Also provides the necessary legal authority to manage, transfer, and sell assets. So there's 3 players in the trust, or 3 positions. The trustor, also called grantor, settlor. It's the person or people who create the trust and transfer their assets into the trust. The trustee is the person who's in charge. There can be multiple people in charge. They're called co-trustees. The first and the second, they can be the same person and most often are. If a married couple or a single person forms a trust, they're the trustor and they're typically going to be their own trustee as well. They would appoint successor trustees. So it's not an executor, it's a successor trustee that's in charge when they are gone or when they're incapacitated and unable to act. And then beneficiary, that's the person who's benefiting from the assets in the trust. Again, they can occupy all three roles while they're alive and in good health. They have full access, full use of everything in the trust. They can amend it or even revoke it during their lifetime. Once they die, once the people who create the trust die, it becomes irrevocable and it's no longer able to be changed at that point. Client can still buy, sell, refinance assets, no change in income tax for the types of trusts that we do, and no change on the property tax bill. Also, I get this question a lot. Well, I have a loan on my house. I don't think I can transfer it into the trust without asking my lender. Not true. There's a federal statute that allows the transfer to be made, and specifically says that the lender can't call the note due or do anything like that. It's called Garn Saint Germain, if anyone cares, but it's any kind of residence. I think the only types of residences that aren't included are like if it's like an apartment building or like a complex with more than three or four residences. So most people's homes are going to qualify for that. And we usually suggest that they don't even tell the lender because it may just confuse whoever they're trying to talk to on the phone. Yeah, they can't do anything about it. So there's even like lenders that won't lend to a trust. People can buy the house in their own names and transfer it into the trust the next day. The lender can't do anything about it.
And the trust is tied to the person's social security number, so it is.
Yeah, they're really not doing anything. They shouldn't do it. It's still them, and they still have to pay. They could still get foreclosed on if they don't. Okay, so like I said, they choose a successor trustee to manage the trust if they pass away or they can't manage their own affairs. They can sell the house even if the client's incapacitated and not deceased. And they can obviously sell the house if the person has passed. It takes away the need for the courts to get involved. Like I said, if your trust is going to court, it's because something has gone very wrong. Benefits of the court not being involved. So if someone becomes incapacitated, they don't have a POA or their POA gets rejected for one of the million reasons that lenders sometimes reject POAs or title insurance companies. There's no need for like a court proceeding to get guardianship or conservatorship over that person. The trustee can sell the house. No need for probate, saves money, time, and hassle. The home can be sold immediately without any delay whatsoever. Really all they need is a death certificate and an updated trust certificate, which is easy. Okay. Be case study person. Says last month again.
Okay. Homeowner passed away last month. Home was in a revocable living trust. Homeowner's daughter is the successor trustee. Can the daughter sell the house? When?
So this is where the pictures get better. So trusts can offer a lot of other protections too. Children that have trouble managing money or have creditor issues. You can set up trusts all different ways. You can ensure that an inheritance isn't lost to bad decisions. You can put someone in charge for a child's whole lifetime. Someone else is going to be in charge of this inheritance for them. You can determine at what age you're comfortable with them getting the inheritance, and you're deciding who's going to be in charge of it until then. Again, what I just said, make sure it's overseen properly for young children. Can be paid out over time as the child gets older, can be used for health, education, maintenance, and support at the trustee's discretion until the child reaches the age that the person who established the trust determined. We can do like special needs trusts. So someone's getting government benefits. The trust can be structured in such a way that it will provide supplemental needs for the child, but it doesn't replace the government benefits or cause them to lose government benefits. So it's a lot. It's a complicated area of law. And if you decide you want to get this in place for yourself, I do recommend that you use an attorney that does this specifically, not an attorney that does everything and also does trusts or wills occasionally. And this is our final advice for you. Get your own affairs in order. I heard on the radio, they say it was like the most immature thing you can do as an adult is not have a will. And I agree with that, especially if you have kids, guardianship provisions for your kids, who's going to take care of them if something happens to you. It's a lot of worst case scenario talks, but you would rather have it and not need it than need it and not have it. And unfortunately, we are all going to need it at some point, and none of us know when. So I don't think there's ever a time that's too early to put a plan in place. Estate plans can be flexible. They can be changed at any time as long as you're alive and competent. So as your life evolves and changes, your estate plan can change too. But I think it's really important, especially if you have kids, to have an estate plan in place. Okay, our information is on the sheet that we gave you, and I'm going to actually pass around a sheet too if anybody wants. We're offering a free consultation with one of us for anybody who's interested in talking about their own estate plan. We can do them in person, we can do them over the phone, we can do them via Zoom. The only time you have to come into the office is to sign your documents. You do have to come in and physically sign. All right.
Have a fee schedule for setting up a trust?
So we do flat fees. And, you know, we kind of discuss everything with you, but typically we're in the like $3,000 to $3,500 range for trust packages, which is going to be a trust, powers of attorney, healthcare documents, deeds. We include up to 2 deeds. But, you know, when I tell people, a will is easy because you're just saying whatever I have when I die, here's where it's going to go. And there's nothing wrong with a will. You can do a lot of things with a will to make things easier on your heirs. But you are leaving potentially some hassle on the backside for whoever's going to be dealing with it while you're gone. And there's a delay. If you have young children, they're not going to have access. No one's going to have access to use that, you know, the inheritance for them right away until probate's done. Trust is kind of opposite. You're paying more upfront, you're doing more work upfront, but you're hopefully streamlining the process on the backside. And remember what I said, our retainer is for probate $2,500, and it doesn't always stay at $2,500. So one way to look at it is a lot of money. I'm not saying that it isn't. Cost is always a factor, but it's going to get paid one way or the other. So kind of decide how you want that to work. And actually, we'll take questions, but I'm going to pass this around. If you want us to contact you, you know, you're kind of procrastinate, we'll call you or email you or text you and ask if you want to schedule a consultation.
Do you have a different fee schedule for someone who already has a trust but they want to update it?
So here's the thing with that. Typically, we won't amend another attorney's work. And the reason for that is when we do that, we're taking on full responsibility for the document that's already in place. So by the time we review it to a satisfactory degree, we may as well have done a new trust for you. So I would say typically we don't amend another attorney's work, but what you can do is a restatement of trust, which is where you keep the same name, so you don't have to retitle assets, but you do basically a whole new trust with the same name.
Now, if you have a trust and you acquire more property or, you know, heavy equipment, whatever, how do you, if you don't put it in the trust, what happens to this?
It's not in the trust. So if you do buy something, title it to the trust.
Okay,
So you would
just need to title
yeah,
everything
you'd buy it in the name of the
Okay.
trust.
You don't necessarily have to amend the trust itself to do that. So if you say, I have 3 kids, if my spouse and I are both gone, everything goes evenly to the kids. Whatever you stuff in that box is going to be even between the kids. So unless you buy a new house and you want it to go to a specific person, then you'd have to update the trust itself and say, okay, 123 Main Street goes to Sally, and then everything else is split evenly between my kids. That's an amendment to the trust. But if you're keeping the same terms and just whatever's in the trust is being split 3 ways, you wouldn't have to amend the trust itself. You just keep adding to the box. Any other questions? Anybody want to share a probate horror story?
My mother-in-law passed away, my father-in-law didn't realize that he had to open a probate, because all their vehicles were titled in both their names. And he went to sell one, and he couldn't sell it because her name was on it. And
If it's not joint with right of survivorship,
Yeah.
yeah, people don't realize that.
I went to Rowan County, I probably made 10 trips. And if you don't dot your I's and cross your T's perfectly and use the right verbiage in the right name, in the right slip, wherever you're supposed to write it, and they cannot tell you how to do it because they're not attorneys. So
Well, they can't give legal advice.
right, they can't give legal
Yeah.
advice. So after 10 trips, I finally figured this out.
Well, and you'll see different counties, clerks are more or less helpful. Some clerks will just say, I can't help you. I can't give legal advice.
I got that. Like
Other ones will be more helpful than that, but you have to get kind of lucky to run into one of those. You're probably more likely to do it in Cabarrus County, from what I understand. Those are supposedly the nicest clerks around. So, anybody else?
Wasn't crazy because you guys took care of it all.
Good. I'm glad to hear it. Well, I will.
have to drive to Florida.
Oh, gosh. Well, I will,
Oh, wow.
I will pass that along. I probably,
They had something signed, but they didn't notarize, and so they
I think I remember hearing that.
Actually, it was.
I remember
it was
hearing about that
notarized,
one.
But it wasn't.
Got it. Well, I will pass that along. I can't probably take any credit for that, but I'm sure everyone else at the office, the title folks can. One other thing that I wanted to mention while we're here, this is our first year participating in the Walk to End Alzheimer's. We're doing it as a firm. Josh Nip has pledged that he's going to donate $10 for each real estate closing and each estate planning signing that we do in September. That's going to be in the $2,500 to $3,000 range. So we are encouraging anyone who might be so inclined to also donate. We also are having a little competition between our offices. So if you do decide you want to donate and you do our little QR code here, you can go to a list of all the people who signed up to be on the team. If you have a paralegal, an attorney, anybody, us for doing such a wonderful presentation for you, someone who you would want it to be credited to their tally, please do. But it's a thing that a lot of people in our office have a personal connection with. I have 2 grandmas and an aunt who all passed away from Alzheimer's, so it is near and dear. We have the QR code on the front here that'll take you right to our team page. And then also if you're old school and you like to mail things, then I have the mail-in form too. So I'm gonna put that up here if anyone's interested, and then I have some business cards here too. Tara's so new, she doesn't have cards yet. They're coming. Any other questions? All right, perfect. Well, thanks, guys.
Thanks.